So we're really pleased and honored today to have our hosts from Effective HR, Corinne and Emma, who are HR consultants. Corinne is the lead HR consultant. Is that right? Yeah, lead HR consultant. And Emma is a consultant that works with the team. They're both SCHADS experts. They know everything to do with SCHADS as it relates to HR and your employees and all the policies. So we're really lucky to have them today because they it's very hard to stump them with questions. So I dare you to try today. So what I'll do is I will, without further ado, pass over to Corinne and Emma so they can get started and we'll get to the presentation. Emma and Corinne.
Thank you, Heather. Good afternoon, everyone. Thank you for joining us today for this very insightful webinar on the true cost of SCHADS Award breaches. Today, we're going to be exploring the significant impacts and the hidden costs associated with SCHADS, with breaches of the SCHADS Award. The topic is absolutely crucial for businesses operating in the SCHADS sector and understanding the costs to help ultimately mitigate risk and ensure compliance. Now to start, an acknowledgement of country. I pay my respects to Aboriginal and Torres Strait Islander peoples participating in this webinar. I acknowledge the traditional custodians of the various lands on which we work today, and I pay my respects to elders past, present, and emerging. Now, before we get into all of the technical content, I'd just like to provide a little bit of an overview about who we are at and what Effective HR does to provide support. In a nutshell, Effective HR provides specialized HR, work health and safety and payroll services tailored to the SCHADS industry, focusing on the unique challenges that businesses face in this sector. We excel in areas such as recruitment, maintaining compliance with the SCHADS Award and Fair Work standards, and we draft documentation such as contracts, policies, and position descriptions that are all specifically tailored for SCHADS needs. We also offer employee management support, work health and safety support, and payroll support, so undertaking audits and setting up HR and payroll systems. Now, I am absolutely thrilled to introduce my colleague, Corinne West, who is a lead consultant at Effective HR. Corinne will be presenting today's webinar and sharing her expertise on the SCHADS Award.
Thank you, Emma, and thank you everyone for joining us today and for having me here today. It's very much a treat for me. I usually spend my 9 to 5 running through this sort of information with individual clients. So to actually be able to deliver this information on such a large scale, it makes my heart happy as a HR professional because I love efficiency. So you've just saved me 500 conversations. So thank you for that. Today's agenda is really focusing around what I like to call the so what. We know that there are rules around engaging employees under the SCHADS Award. We know that they're not easy to understand, or let's be honest, practically apply, given participants' different service requirements within the industry. But so what if we don't follow them, right? Are there consequences? What are the consequences? So we're going to be working backwards from that point to be able to understand the importance of compliance, the costs of non-compliance, and understanding some common award breaches that we see happen often with our clients. So for context, I do work directly with NDIS providers that are both large agencies and what we call service for one families. So that makes up approximately about 90% of my working hours each week. So not much surprises me in this space at the weird and at times not so wonderful SCHADS Award provisions. So we are going to have time at the end for a good juicy Q&A session, often the highlight for most attendees, and I know myself as well. As we mentioned earlier, there's no need to wait till the end of the webinar to submit your question. Feel free to submit your questions throughout the presentation using that Q&A function, and we will run through those at the end. Okay, so I mentioned before the so what factor when it comes to SCHADS Award breaches. In a nutshell, there are 4 key risks that we've identified as implications for not abiding with the SCHADS Award. So specifically being those monetary penalties for committing award breaches. We have increased wage costs that come from non-compliance. We have underpayments of wages claims, and then the remedial processes associated with those claims and the costs involved. And last but certainly not least, reputational damage. I think this is one that we often overlook, but arguably in this industry, it's what matters more than the dollars and cents, right? So jumping into the dollars and cents here, looking at what those fines for what we call technical award breaches are. So if you're a small business, so this is where we're talking about organizations with 15 or less employees, we're talking anywhere between $93,900 and $939,000, depending on the severity of each contravention. And that is each contravention. So each occasion there is an individual breach. For a non-small business, being 15 or more employees, we're starting to look at $469,500 up to $4.69 million. Again, per contravention. If you've got 20 employees, we're paying each person wrong. This is going to start to talk about huge numbers. A good rule of thumb when it comes to award compliance, that I want you to remember, is that if the award is silent on it, the default position should be that it's not permitted under the award. There are, of course, options that we can look into to find a way to be compliant, but it's not something I'd recommend navigating through by yourself, as quite often I can get stumped. Even with a law degree and 11 years experience, it can be tricky to find a way to navigate through compliance here. So as I mentioned before, we have those fines for non-compliance that you can see on the screen, but we've also then got other costs associated, being increased wage costs and underpayment costs. So we're going to look at those now, and I'll explain them in a little bit more depth. So when it comes to increased wage costs, what is this all about, and how is it linked to non-compliance? So if we go back a step, if we've got solid rostering practices, obviously being a ShiftCare client, that's a good starting block for sure. Those solid rostering foundations should mean that overtime and certain penalty payments, obviously excluding those usual suspects such as weekend or public holiday penalty rates, overtime and other penalty payments should generally be kept to a minimum to ensure efficient rostering and payroll practices. We don't want to be paying someone overtime rates to do a shift if there's another person available that can be doing it at an ordinary rate, right? So to achieve this, we need to understand what types of shifts or what types of rostering practices are going to trigger that additional payment. So on the screen there, I've got some information around overtime payments in accordance with the award. So the first point here is something that will trigger for part-time casual employees as well, working in excess of 38 hours a week or 76 hours per fortnight. When we're talking about how many hours we can work in a day, it is actually set at 8 hours a day for full-time employees. It can be extended to 10 by mutual agreement. We're going to want to make sure, though, that we've got a paper trail or we've got something in writing covering that mutual agreement. We've also got this idea of what we call the span of hours. So if you are classified as a day worker, then your ordinary working hours are going to be between 6 a.m. and 8 p.m. Now, if we're working outside of those hours as a day work, overtime is automatically triggered. And we'll talk about that in a little bit more depth later. There's also overtime payments where we are not providing a meal break after 5 hours and what that looks like when providing care for participants. Also, if we're working more than 8 hours of active work during that specific 24-hour care shift, that will trigger overtime. Now, separate to overtime, there's what we call penalty payments. And those penalty payments are triggered in things such as broken shifts. So if you have a broken shift rostered and the span of that shift is in excess of 12 hours total, that will trigger a penalty payment. And if we've got insufficient rest breaks between work where overtime has been worked on that shift prior. What's interesting here, and something not a lot of people know, that there is actually a difference between overtime rates and penalty payments and how they're processed in payroll. So while often the amounts are the same, your Saturday rates are similar to your overtime rates, might be similar to a penalty payment that's triggered, it's important to make sure that they're actually processed and categorized correctly. Because what actually happens is superannuation as an entitlement. It's payable on some earning types, but not on others, such as overtime. So it's quite often I have seen clients that are underpaying earnings, but overpaying superannuation. So we really need to make sure, based on these nuances, that our systems are set up correctly to reflect that. So it's something our systems and audit team work with daily with our clients to achieve. If you're not sure about that, please take a note and reach out to us, and we'll be able to provide some clarification on that. And most importantly, when we're talking about these increased wage costs, what I hear from clients in the industry, and obviously it does vary on a case-by-case basis and depending on funding, but as an working with the NDIS funding model, is that if you're paying an employee overtime rates, that might actually equate to more than what you can actually bill for that particular client and what's being funded there. So if you're paying more in costs than what you're receiving in revenue, I think that's business 101, that's not going to be sustainable moving forward. So thinking about ensuring minimal overtime on our roster is going to be really important there. Similarly, overtime is something that is quite often an afterthought or a reactive cost. We don't plan, or we shouldn't be planning for too much overtime. So it often is overlooked in company wages budgets. So if we've got a high amount of overtime payments, then it's not going to be viable for companies like yourself who, quite frankly, what I see are operating on already such small profit margins as is, to be paying out that overtime. In terms of what the impacts of underpayments are, I've got a little bit of information on the screen there for you. Something I mentioned earlier, one implication of not abiding by the SCHADS Award is that we may, as a result of not abiding by the SCHADS Award, underpay employee entitlements that are derived from the award. So I've got to be honest, seeing underpayments of wages issues is a daily occurrence for us. And quite often it's businesses that are trying to do the right thing and trying to be compliant and don't even know that they've done something wrong. Because again, the text that is the SCHADS Award is so complex to navigate. So the most common issues I see that cause underpayments with our clients and things, I guess, to note down and check is an incorrect payroll system setup. So if you're using payroll software that doesn't have all of the award terms built into it, for example, you're just using your standard accounting applications like Xero or MyOb, chances are that they're probably set up incorrectly and not paying all the entitlements that you need to be paying. I quite often see companies, attempting to incentivize staff to do shifts that, they might not prefer, such as sleepover arrangements. So, taking a look at sleepover allowance in the SCHADS Award and saying, oh, we'll pay you more than that. We'll pay you $100 to do a sleepover shift. But that allowance also covers the first hour of active duty. No, it doesn't. It's not going to pass what we call a boot calculation, so a better off overall test calculation. And that we see result in accidental underpayments. So if you do have arrangements like that in place, I'm not saying you can't do it, but I'm saying let's actually check that it's going to be enough to meet those requirements. Employees that are paid above award flat rates quite often happen. So, people are looking at the SCHADS Award, hopefully they're classifying their staff correctly and they say, oh, I'm actually going to pay you more than that. And that's fabulous. You're welcome to do so. If you're doing that in lieu of paying, say, a Saturday rate or a night shift allowance, we need to tread really carefully around how that's managed to make sure that the employee is better off overall with those conditions, and that we're regularly reconciling those calculations to ensure no accidental underpayments. especially with wage rates going up each year. Very important to be across that. And also having it in our written contract of employment, specifically what award payments are absorbed into that hourly rate. Is it an afternoon shift rate and a night shift rate, or just one or the other? That level of specificity is going to be required to ensure compliance. So again, like I said, most organisations we come across, they want to do the right thing. Having said that, though, there is legislation covering those what I colloquially like to call cowboys in the industry for those that don't. So when we start talking about wage theft, that term refers to employers that are knowingly underpaying their employees and thus stealing from them. So employers found guilty of wage theft, there are severe penalties in place, which you can see on the screen there. We're talking really big fines, and actually it's become a criminal offence, so imprisonment in some states. So this is currently already in play for New South Wales, Victoria and Queensland, and from 1 January 2025, it's going to be covered nationwide. So what's, I guess, interesting for myself that I see with underpayment cases that have actually gone through the Fair Work Ombudsman, this is in the situation where they might be audited or investigated, a particular company or a spotlight on a particular industry. You know, if the Fair Work Ombudsman is finding these non-compliance issues, quite often the fines that they enforce are actually 10 or 20 times the actual amount of the underpayment. I've seen a case where there was an underpayment of about $40,000 in wages, and the company was actually fined $500,000. So there are huge fines that are happening here. I think another hidden cost when it comes to the underpayment of wages is actually the cost of rectifying it. It quite often can even be bigger than the cost of the underpayment. So, you know, if you're looking at the last 7 years of underpayments, or even the last 2 years, because we haven't been paying a broken shift correctly, or we haven't been paying a sleepover correctly, the time that's spent auditing and recalculating those figures in payroll, getting external companies, let's be honest, like ourselves, to run that project, or the legal costs involved in responding to an underpayment claim that might be made in a state tribunal, the reputational damage that you get. I don't know if anyone subscribes to the Fair Work Ombudsman weekly updates, where they'll quite often be like, we got him, here's another company, and there's your name plastered all over the 6 o'clock news, which is not fun. So there are a lot of costs involved in that. So the quicker we can get on top of it and get that status quo being compliant, the better it's going to be for you. Okay. Now, in terms of common award breaches, this is what I want to spend a little bit more time looking through some detail of what they are. So the key issues, I guess, I see here with our clients are ignoring minimum engagement, misclassifying employees. So are they in our home care stream? Are they in our SAC stream? What does that even mean? And looking at those correct classifications. Not providing meal breaks, how we navigate broken shifts, what our maximum weekly hours are and the consequences there, understanding sleepovers, employee travel issues, breaks between shifts, and understanding the consequences of whether someone's a day worker or a shift worker, and how to compliantly make sure that we're paying everyone there. So first things first, we're talking about our minimum engagement. So where we're talking about part-time and casual employees, let's focus, I guess, specifically on support workers, because I'm imagining that's the bulk of your workforce here. For home care employees and social and community services employees, where you're undertaking disability services work, you're looking at a 2-hour minimum engagement is the core there. So for full-time employees, interestingly, there is no minimum engagement. However, you need to meet their 38-hour-a-week roster based on the provisions that are on the slide there. It seems simple enough to me, but I guess the key takeout for this one is that where minimum engagement is not met, you're required to pay those hours. So And I've seen this happen before with clients. If you're rostering a support worker to see one client for 1 hour of support, and that's the shift, you're actually required under the award to pay for 2 hours. So you can roster a support worker to see multiple clients within a shift. We'll talk about what that looks like with TravelWise shortly, but you're going to want to know this now and be rostering that minimum 2 hours rather than going back and back paying someone for an hour worth of work they didn't do, because that stings, right, when it comes to efficiency. The next point I want to move on to is around the misclassification of employees. So where we're using the home care stream or the SACS stream. If I had $1 for every time someone got this wrong, my mortgage would be paid off by now. It's very common and it's very complex to work through what is a technical discipline of determining award coverage. So if we're going to take this back to basics, we've got our SCHADS Award, and that provides industry coverage for 4 different sectors. Now, 2 of those sectors relate specifically to disability services and NDIS providers such as yourselves. And they are called the home care stream and the social and community services sector, or like what we like to call the SACS sector as an acronym. So SACS is one part of the SCHADS Award. I like to colloquially call them streams, so I'll use streams and sector interchangeably. Hopefully that doesn't cause too much confusion. When we're thinking about our home care stream, from a support worker perspective, we're talking about covering things like core supports and daily assistance that's completed in a participant's private residence. So, thinking about meeting their physiological needs, assisting with daily activities, getting dressed, getting fed, medication administration, those sorts of day-to-day living tasks, if you will. The SACS stream, it's typically from that support worker perspective going to cover community-based capacity building and recreational activities with participants. It covers support coordination and related services, and the provision of SIL and FTA housing. So this idea there, it's not gospel. Working out whether you as an organisation are providing home care services or providing SACS services, because that's the level we're looking at it on an organisational level, it can be very nuanced, and it can even depend per participant, but we need to review this on a case-by-case basis. The so what factor for that is each award stream is going to tell you what the entitlements are. So we need to make sure we get that right as a foundation level. So the way I guess myself and Emma, when we work with clients, determine what that stream is, we're going to get to know you, understand your business, understand the different aspects of service delivery, understand what your participant care needs are, look at how our employees work and how they're rostered, looking at what their background is and applying all of that information to come up with a determination and a bit more confidence of how you're working that one. I quite often get asked if I can use both streams to cover my workforce. By default, I'm going to say no. That's not a hard and fast rule. I'm not saying it can't be done, but typically an organisation is going to naturally fall into one or the other, and the lines don't often blur. So it is something that does need to be reviewed. I do often as well see stream coverage work on a per client basis, but my answer to that is similar to the above, being generally speaking, it's not going to be like, oh, I've got a home care client here or I've got a SACS client here. We're looking at it more holistically as an organizational structure, as a service structure, as what our employees are doing. Because when it comes to classifying our employees, such as a SACS employee level 2 or a home care employee level 2, that's actually linked, like classification is linked to an employee's employment. Their base rate is derived from that classification. So that shouldn't vary on a specific shift or a specific client basis, generally speaking. In terms of clerical employees, so thinking about those office-based workers that might be doing rostering or intake services, the paperwork, all other sorts of tasks that are involved in running an NDIS organisation. Generally speaking, you're going to have your clerical administration staff for SACS organisations covered within the SACS streams. Generally not so much with home care. So if you're a home care business, the Fair Work Ombudsman's default position is that it does not cover administration employees in home care. However, again, I think it's a bit more nuanced and we want to look at it in depth to make sure that's right. In terms of why this stuff matters, and I touched on it before as well, that award coverage and that classification forms the basis of what those employee entitlements are and what you need to do to be compliant and not breach the SCHADS Award. So if we're getting it wrong, we're ultimately going to be non-compliant. But generally speaking, there's differing rates of pay across the streams as well. So generally, SACS provides for higher rates of pay. So if we're misclassifying someone as home care when they're really, it could relate in an underpayment issue. So we really want to make sure that we're across that. Oh, sorry, I've gone a little bit crazy there with my slides. Spoiler alert. The next thing we want to look at here is around meal breaks. Now, this is something that I generally see a really good understanding when it comes to NDIS providers, but doing a quick recap here. So if we've got an employee that's on a shift of more than 5 hours, they must take a 30 to 60 minute unpaid meal break. So that's where they're completely free from duty. If they want to leave and go through Macca's drive-through, they're able to do so. If the employee is not given a meal, they will be paid overtime for all time worked afterwards until that break is taken. Unless, and I will give the SCHADS Award a gold star here for practicability. It's the only one they're getting. If the employee needs to eat with the client as part of their normal work routine, so they're not able to leave, they need to stay, but they can sit down and have a meal together with the participant or be able to step away to do that, then they're going to receive their ordinary rates for the time of which they've worked there, including that eating time. So it's really important to make sure that your payroll is set up correctly, whether it's payment codes of meal had with client or no meal break being categorized correctly to ensure those proper payments are made, either at their flat rate or at overtime rates, or actually counting that break and that not worked time. Generally speaking, if you've got a break in your roster that's going to be more than 60 minutes, we're going to count that as a broken shift, or we recommend be counted as a broken shift. And we're also then looking at payment of a broken shift allowance, which is a great segue into my next slide, being broken shifts. So this sort of shift structure is only permissible for home care and SACS employees where they're performing disability services work. So again, let's put the lens of this as looking at your support worker team here. I mentioned before, when is it a broken shift? When is it a meal break? The award does not actually define the length required for a broken shift, but we kind of work backwards in going, well, if a meal break is 30 to 60 minutes, if I'm doing a break of less than that, I may as well just roster it as an unpaid break. So if it's over 60 minutes, it's where you'd look at applying a broken shift. So when we're rostering broken shifts, we want to make sure that we're paying the broken shift allowances and making sure that we're paying the minimum shift per part of work. So coming back to that 2 hours for our support worker team. So at least 2 hours in each segment that's broken into. So generally speaking, we can break a broken shift into 2 parts. So 1 break between and 2 sections of work on the roster. And that can be broken into 3 by mutual agreement. So we can't direct that 3rd one, but if the employee is agreeing to pick that up, which is easy enough to do in your rostering software, then we can do 3 by mutual agreement. Generally speaking, I like to say that sleepovers and broken shifts don't mix very well. They're not going to work out well for you. And the reason being because the award does not provide for a sleepover within a broken shift. Because a sleepover would actually go over that 12-hour span and you're left paying penalty payments. And again, we've spoken about how that's an inefficient wage cost. So when we're reviewing our roster with the lens of the information we're learning today, we want to make sure that they're not really connected in that way. There's probably going to be a better way to roster that, or hopefully a better way or a better strategy can be implemented to do so. So when we're paying broken shifts, essentially traveling between a client is not actually a broken shift. So if you've just got one shift on our roster, I've got participant A and participant B, and I'm just driving between the two, might be 15 minutes or something like that. Generally speaking, that's not a broken shift. We'll talk about employee travel shortly as well. If a broken shift is performed by someone that's classified as a shift worker, one part falls into the afternoon or evening shifts, it's only that one part that's going to be paid with shift penalties as well. So again, making sure that we've got all of that set up correctly. Turning now to maximum hours of work. So I've got some information on the slides for you there, but I want to run through something that's fascinating, I think anyway, that we've recently had confirmed by the Fair Work Ombudsman. So we came up with a hypothetical scenario that we have seen for clients as well. So take this example, we have an employer and they're engaging a full-time employee. So 38 hours a week is what they're going to be rostered for. Now, this full-time employee gets rostered for one 12-hour shift as part of their 38-hour week roster. So based on this shift schedule, that employee is going to be paid 36 hours at ordinary earnings and 2 hours at the overtime rate because that shift has exceeded the maximum length of 10 hours we're talking about earlier. So in this instance, the Fair Work Ombudsman has confirmed that full-time employees must be rostered for 38 ordinary hours per week. So in this scenario where the full-time employee, they've been rostered for 38 hours, but based on the way that they've been rostered, 2 hours has been paid at overtime and 36 has been paid at ordinary hours. The employer is actually in this scenario obligated to either pay the employee the additional 2 ordinary hours or roster the employee to work those additional 2 hours to meet that requirement, plus the 2 hours at overtime rates. So this similarly applies where overtime might be triggered in accordance with the other provisions of the award. This is just the specific scenario we've got here. But it's worth going back now and looking at our rostered shifts and going, okay, is any of these normal shifts that we've got on there triggering overtime under any of the rules? Because actually we've then got this liability here of I was meant to be paying the 38 ordinary, even though they've worked 38 hours in a week. So it's a really tricky spot that I think a lot of businesses will find themselves in with that interpretation that's been confirmed. Okay, hopefully you're all still with us and I haven't put you to sleep. We'll have a look now at sleepovers. So this is an increasingly common shift type that I'm starting to see. And let's be honest, the award terminology that governs how these shifts are to be structured, it doesn't align nicely to the NDIS guidelines. They're quite frankly written in 2 different languages, if you ask me, which is causing a lot of frustration and confusion for employers around how to pay it. So the key considerations I have for paying sleepover shifts and ensuring compliance with the SCHADS Award there is that minimum engagement is actually 4 hours on a sleepover shift. So on one side, it has to be a minimum of 4 hours. So it can't be 2 before and 2 after. It's got to be at least 4 on one side. So if you're not rostering that, again, that minimum shift is still required to be paid. So we've had to support clients to back pay those additional 2 hours that haven't been worked because we didn't know about it at the time. The client didn't know about it at the time. Again, a really efficient cost that hurts. So making sure that that's structured correctly. What's really interesting with these sleepover shifts is that if we've got 4 hours on one side of the sleepover, the other part of that does not need to abide by any minimum engagement. So as an example, you could have 4 hours in the evening and no hours in the morning. Shift ends at the end of the sleepover part. Or you could have 1 hour. They are perfectly acceptable ways to roster that sleepover shift. In terms of what we categorize a sleepover as, is it a break? Is it a break between shifts? No. I like to think about rostering a sleepover as like pressing pause on the shift. So anyone that's as old as me that remembers the old tape deck, so you're pressing the pause button there. It doesn't break the continuity of the shift, but it doesn't count as time worked. So just thinking about it like that when we think about how we're rostering, how we're paying penalties to ensure compliance. So if someone is doing work during a sleepover, they need to be paid a minimum of 1 hour, and this is at the overtime rates. So that could be, you know, if they're only up for 6 minutes requiring work, they're still getting paid the 1 hour. I often get the question from clients of my staff member couldn't sleep because the participant was up or chatty or whatever it might be. There's a difference between whether or not my support worker sleeps and whether or not they're required to work. So just understanding that and making sure your shift reports and those practices are in place so that you're able to clarify that for payroll and compliance perspectives as well. If you're working multiple times during a sleepover shift, but it's less than 1 hour in total, say you're getting up, you know, for 3 6-minute intervals, the 1 hour doesn't start each time you get up. You know, it's paying a minimum of 1 hour. So in those intervals, it could be considered in the one. So we're not paying for 1 hour for each time they wake, but we're paying a 1 hour minimum payment if they are required to work during that time. Travel is a big one that I see a lot, and when employee travel is required. So this one here, an employee is when they are involved in traveling on duty. If the employer cannot provide appropriate transport, all reasonably incurred expenses in respect to fares, meals, and accommodation will be met by the employer. This is on the production of receipts and other evidence that's considered acceptable. So that's what our award is saying about travel. What this means in practical terms for yourself to ensure compliance is, firstly, we've got a 99 cents per kilometre reimbursement when a support worker is driving their personal vehicle, say for transporting a client, for outings or medical appointments, and if they're driving between clients' locations within a shift. So that's excluding broken shifts. This is going from participant A to participant B within the same shift. So as well as paying that kilometres reimbursement, both between participants and with participants, we also need to be paying travel time. So what I mean when I say travel time is ordinary earnings at the ordinary rate of pay, obviously depending on what that shift structure looked like previously, to be paid when traveling between clients on a single shift. So, you know, if we've got participant A is being serviced from 9:30 to 10:30, it's going to take you 10 minutes to get to the next participant, and then the next one is being serviced from 10:45 to 11:45. That 15 minutes in the middle is paid work time. It should be considered paid work time. It's something as well that when they're traveling for work, so the sorts of costs that need to be covered on excursions, essentially it's all employee costs. So that was what was mentioned in that earlier definition. It's meals, it's accommodation, as well as their wages. So excursions are a whole other minefield, and I'm happy to go through that individually for those that might require the extra support, because they're not so common, but definitely worth getting extra support and clarification on. In terms of rest breaks between shifts, this is an important consideration. So what we see the award saying is that we need a 10-hour rest break between shifts. That break can be reduced to 8 hours by mutual agreement where contiguous with a sleepover. So we want to make sure, again, we have something in writing where they're reducing that break to 8 hours by mutual agreement. So it is a technical award breach issue where the break is not rostered, the sufficient break is not rostered. There's no financial penalty if the 10-hour break is not given between shifts. That doesn't include overtime. However, it becomes a technical breach of the award. So it's one or the other. the penalty payment for not giving a 10-hour break is actually in clause, and just to get a bit technical here, 28.3. So it's setting out when we're talking about full-time and part-time employees, so permanent employees working overtime, they're required to be given at least a minimum break of 10 hours between when they finish working the overtime on one day and they start work again. So if this break is not provided, there are penalty payments that apply for full-time and part-time employees. Interestingly, though, if casuals don't receive that break, they don't have any particular monetary payments associated, but it is still a technical breach. What's an interesting fact as well that we got confirmed after our last appearance, partnering at the recent ShiftCare event, you can actually have that 10-hour break within a day. So you might have 2 shifts, not considered a broken shift, in one day. So you might have one shift from 6 till 9 a.m. and you might have a second shift from 7 till 11 p.m. The shift is not broken. They're 2 separate shifts in one day. Obviously, there's shift allowances or overtime rates for day workers here, but not actually considered a broken shift or a span of hours issue. Pardon me. Okay, my last technical topic, so hopefully you're staying with me here. Talking about shift workers and day workers, and I have mentioned that in my language in the presentation. Hopefully you've switched on to it, but let's go through it now to make sure that we're across it. So misclassifying workers as a day worker or shift worker, or failing to really give consideration to this and make sure that's set up correctly in your systems, could result in underpayments or an incorrect calculation of leave entitlements. So some shift workers are entitled to an extra week of annual leave if they meet the criteria that's there on the screen. What I find fascinating in this area is you can be a shift worker and not entitled to the additional week leave, because we have different definitions of shift worker in the award versus the national employment standards that require that quantum of leave. So as an example, I could be a shift worker. My ordinary hours of work, say, are 6 till 11 p.m. Monday to Thursday. It makes sense to classify me as a shift worker, but I'm never going to meet the requirements on screen to trigger that extra week of annual leave. The key difference when it comes to paying shift workers and day workers and making sure we've got this correct for compliance, essentially day workers are required to abide by that ordinary hours between 6 a.m. and 8 p.m. for shifts worked. So anything they're working outside of that, they're going to get overtime fees. So as an example, if you have someone classified as a day worker that is working from 12 till 9 p.m., that component that is 8 till 9 p.m. is going to be paid at overtime rates. However, if you have a shift worker that's on that same shift, they're actually going to be paid 9 hours at the afternoon shift rate penalty, which is an additional 12.5% for the whole shift. So interestingly, in that example, it's actually works out cheaper to pay an hour of overtime than for 9 hours of a loaded rate. I just wanted to wrap up, I guess, my component here in bringing it back to that so what factor. I'm sure you all understand, you're obviously diligently joining this to gain more understanding and knowledge here, but compliance is going to be crucial to your business success. So how we go about ensuring compliance with all these technical little components we've just discussed. First things first, it's going to be routine system audits. So reviewing how shifts are structured to eliminate any award breaches or inefficient wage costs. Auditing your payroll system to check it's set up correctly, it's not missing any award entitlements, especially as that award updates and changes as well. Looking at internal team training. So obviously you're on the call today, but who else needs to hear this message? Who else can confidently in your organisation need to apply the SCHADS Award provisions? Further education on what this means for your organisation. Of course, we can deliver that in training sessions and work with you to build a compliant HR framework. And then it's putting it into practice. So, quite often people that endeavour to do the right thing do find these issues and do find these accidental breaches. So with that change management about righting those wrongs, if you've been paying incorrectly, there's a process to rectify that. we need to think not just about the dollars and cents, but also that consultation requirement that might be required if we're making changes, and developing a more holistic strategy of what messaging goes out to staff around that issue to ensure that we're not going to have a disruption for service delivery. Oh, I've jumped ahead there, Emma, but I will pass back to you to just do a little bit of recap before our Q&A session.
Fantastic. Thank you, Corinne. That was fantastic technical content on the SCHADS Award. Now, just to wrap up this afternoon's webinar, everything that Corinne has mentioned today is areas that we can provide support in. We work heavily in the SCHADS Award, understanding those complicated clauses and ensuring that businesses receive that appropriate support. So we're very equipped and have high expertise with the SCHADS Award, along with things like your Fair Work industrial instruments. We draft documentation, we provide support with employee management, we do safety, we do audits. So as part of a complimentary benefit for today's webinar, we are pleased to offer a complimentary consultation session. There have been so many amazing questions come through. I have tried to answer as many as possible as Corinne has been going through the content today. If I wasn't able to get round and answer your questions, or if you do have further HR, safety, or payroll questions that you would like some further clarity on, please scan the QR code that's in the webinar slides. There is a section on our website for a free compliance check, and I'd be happy to organise a day and time to go through anything specific to your business. All right, so to wrap up, we've had lots of questions come through in today's webinar. Corinne, are you up for a few more questions?
Let's go. Let's make the most of our time.
Fantastic. So one of the questions that came through in a few different ways was understanding really the difference between home care and the social and community services sector. You know, it has similar terminology, particularly under that social and community services sector, but how would you explain the key differences between the two streams and when they should apply?
Yeah, really good question. I want to caveat again, and I sound like a broken record in saying it very much is a case-by-case basis because it is so complex. But the starting point and where I want to direct our attendees today is clause 3 of the SCHADS Award. It's our definitions and interpretation. And in there, it's got a written definition of what is home care and what is SATS. Home care one is quite a simple, nice one sentence that is around providing personal care, domestic assistance, and home maintenance for I think it says an aged person or person with a disability in their private residence. I'm sorry, I don't have it in front of me right now. So the key kind of terms we pull out of that is private residence. So, you know, that's my home. It's not like a still property that's been operated by the company or a group home setting or something like that. And then also thinking about the fact that it is around that personal care, domestic assistance, home maintenance. So really kind of, you know, getting through the day-to-day care requirements, right? The social and community services definition is a mouthful. It's about 4 or 5 lines long. It goes into youth work, recreational work, welfare work, disability advocacy work. But then the last kind of 2 lines, again, apologies, I don't have it in front of me, talks about the provision of disability services and talks about it being, you know, that might be personal care or lifestyle support in a community or residential setting. So residential setting is different terminology to private residence. And that's where I kind of link that to going, okay, well, you know, whose property is it that we're going into to provide that support? What does that look like? And then thinking about what those supports are in the community. So, you know, if generally speaking, you know, your organization is set up to provide that you know, even in the aged care space in setting up to have people under the CHSP funding, where you're going in, you're doing a little bit of cleaning around the house, having a cup of tea, keeping them company. That's very much kind of textbook home care kind of work. But if a lot of your participants, the kind of support work you're doing is taking them to their jobs and assisting them, supervising them in employment or studies or schooling, or more of those community enrichment and skill building activities, then we're going to start looking at that side of things. So I'm sorry, I feel like I've really gone off on a tangent there. I forgot we're in a Q&A. But yeah, I think the key point is look at it on a case-by-case basis per organisation, and it needs to be determined SCHADS or home care on an organisation level around services as opposed to each individual participant, and then we can trickle down to classifications once that's determined.
Fantastic. No, I think that's a really great example to show that the award is so complicated, and a lot of the time the advice that's provided is so tailored and so specific to the business and that situation. So it's very difficult to provide general answers without knowing all the background and the specifics. Another really good question, and it's a question that I've come across previously with another business covered under the SCHADS Award, is around classifications. Can a support worker be paid at a level 1? I've heard that people mention that they need to be paid a minimum of a level 2.1. So, Corinne, can we pay a level 1? Is the award has it in there, but can it be done?
This is such a good question, and to speak really colloquially, and I would say off the record, we're being recorded, I totally got into a fight with a union rep about this. So let's make it stream specific, because the classifications are different across the stream. So starting with home care, there is a level 1 classification. For me, when it comes to putting staff in there, that it's quite limited, and the reasons why it's limited is in the home care space, it specifically talks about having less than 12 months experience in the industry. So not with you as an employer, in the industry. What is the industry? Not defined. So if they've come from a similar NDIS provider, or even something comparable like the aged care industry or SLSO support or something like that, that would arguably be considered industry experience. Again, with that home care level 1, so we're only covering for up to 12 months in the industry, but it doesn't actually speak about personal care. It talks around, it actually specifically says the watering of pot plants, which I love. I love that it went into that level of specificity. But it's more focused on like those peripheral care duties. So tidying the home, or, doing some meal prep and some cooking and cleaning, as opposed to actually physically supporting someone with might be, their personal hygiene needs or things like that. So very limited in the home care space. SAC space, it's a little bit more common, I would say, to have someone classified as a level 1. Things that might limit that would be depending on their qualifications and whether or not you recognise or ask for, in your recruitment activities or your position descriptions. If you're sitting there saying, I need someone to have a Cert 3, and that's relevant to the role, then potentially we need to be paying that for that qualification, if that makes sense. There is coverage for support workers, very much so, that don't require qualifications or don't have qualifications under level 1. Specifically though, and again, I don't have the award in front of me, when it looks at the classifications there, it's like got subsection G and subsection H that talk about whether you're doing what feels like a little bit more peripheral personal care work with participants in that direct contact. And then the next one is defined as, I think it's H, as like, a full suite of disability services. So depending on the way your organisation is structured and the services that you provide your participants, I would say conservatively, you always jump to that subsection H that you would rely on for classifications. And then the kind of so what factor for that is underneath that, it says, well, if that's what they're doing at that subsection H, they need to be paid at a level 1 Paypoint 2 as how they enter that classification structure. So Paypoint progression is a whole other topic. I don't know if we have any questions on that. I don't know if I have time in the 4 minutes, but it's also worth considering it within that classification.
Yeah, and what we do at Effective HR is we actually have created an assessment tool on Paypoint progression, because there are so many different factors. You know, if you're wanting to, for example, hold somebody back from progressing down that, you know, Paypoint progression, how do you go about it? So we've created an assessment. We ask lots of questions to understand your business, your employees, so that the advice that essentially is provided is tailored. Conscious of time, there's so many questions. And another one that we got lots of questions around was regarding minimum shift engagements. There were questions around, does minimum shift engagements apply if we're doing one-to-ones, if we're doing training shifts? Do minimum shifts, Corinne, apply in all circumstances for work?
That is such a good point. Do you see my face light up with that? Because anytime I get a chance to talk about clause 2510 remote work, I'm in there, right? So very good question. And I guess the default is if it's a rostered shift, then we're going to be looking, you know, generally speaking, at that minimum engagement. The exception to the rule would be if someone is doing what we call remote work. So the definition of remote work is contained within clause 2510 of the award. And sorry, I don't have it in front of me right now, but essentially it goes through, you know, what is a remote work shift. So that might be if you're not required to physically be in the workplace, or it's not on your roster or anything like that. So we typically would be using this for like team meetings. If we want everyone to come in at a special time, we want to pay them, but we don't want to pay the 2 hours. It's got specifically says you can pay 1 hour for that. When it comes to remote work, there's also the payment of an on-call allowance if we have someone on call or not. And then you've got, depending on the times of day, the minimum length that you're paying for. So whether it be a 15-minute increment and whether I'm paying that at a loaded rate or not, and then tracking that. So we really commonly use remote work clause for people that do the after hours servicing. So if what you offer is a 24/7 line for participants, or depending on your size for staff, you know, calling in sick and things like that, often the person monitoring or taking those calls, we can use clause 2510 to cover that style of working.
Fantastic. And we'll do one more question, which I thought was a great question, is if we are currently overpaying our casual and permanent staff, are we allowed to realign that wage to the award?
Really good question. It's not great news as a result of the answer. And I do see this happen a lot, you know, accidental overpayments, if you will, with that. Now, the key thing that I kind of link to here is it in a contract? So, you know, without stepping too far away from SCHADS territory, employment contracts is a whole other legal realm in and of itself. And you should see me nerd out on that. Love it. But essentially, you know, that employment contract is a legally binding agreement that can only be changed by both parties signing off on it. So even if you're overpaying someone, if you've put in their contract that rate of pay, we've agreed and signed off on it, we can then only lower that rate of pay with the dollars and cents by them signing off on it. And let's talk in practical terms. No one's really going to sign off on that, right? To get paid less to do what they were, you know, getting paid to do previously. There are ways to unilaterally change classifications, and there are ways to restructure the organization if that's happening to achieve those objectives, but it's very, very much a complex territory that would probably need more than the no minutes we've got left. I'm sorry.
Yes, no, I think contracts are the absolute foundations. You know, all employees, including your casuals, should have a contract in place that sets out terms and conditions, and most importantly, is specifically tailored to the SCHADS Award and your business. Perfect.
I'm giggling at William's comment there. He just put into the chat. Thank you very, very much, Emma and Corinne. This was incredibly informative. If we didn't get to your questions, make sure you reach out, you scan that QR code, make sure you reach out to Emma and Corinne to ask your questions to them and get some advice specific to your business, to your company. And what I'll do is I'll take the questions, all of them, the ones we got to and didn't get to, and I'll get them put into a blog post or something that we can put on the website, so you can come back and we'll get the answers from from Corinne and Emma, and we can put that on the website so you guys can make sure you can also get some answers. But it'll take me time to do that. So make sure you reach out to Corinne and Emma first, because you'll get answers much quicker than waiting for me to collate all of these, because there was many. I think there was close to 100 questions. So yeah, very informative. Yeah. Thank you very much to both of you. Thank you for your time. Thanks for answering all the questions. Thanks to everyone who attended. Thanks for taking time out of your really busy day. I'm sure everybody has lots to do. And stay tuned for more webinars. There'll be another partner webinar coming up next month. So just make sure you check your emails and the website, and there'll be more information coming soon. Thank you, ladies. Thank you, everyone.
Okay, thank you.
Bye.
Bye.